This is a recitation of what the judge will read to you if she or he imposes a sentence upon your pleading guilty. It will not be read if you receive a suspended imposition of a sentence. Only a sentence to be executed immediately or a sentence that will have a suspended execution or an SES. This is what the judge will read regarding your right to file a motion to vacate, set aside, or correct the judgment or sentence. Now that I have imposed a sentence, you can file a motion under Rule 24.035 if 1. The judgment of conviction or sentence imposed against you violates the Constitution or the laws of Missouri or the Constitution of the United States. Although the judge will not say this does include claims of ineffective assistance of counsel. Number 2, the court imposing the sentence was without jurisdiction to do so. Or 3, the sentence imposed was in excess of the maximum sentence authorized by law. This Rule 24.035 provides the only way by which you may seek relief in the court for the above claims. Criminal Procedure Form Number 40 is available to you at no cost upon your request for filing this motion. And I make a note here that the form is available through links on this website. The judge will continue. Any motion to vacate, set aside, or correct the judgment and sentence under this rule, 1, must be filed with this court within 180 days of an appealable judgment or sentence being entered, unless you appeal this court's judgment or sentence. Or 2, if an appeal is taken, it must be filed with this court within 90 days after the date the mandate of the appellate court issues affirming the judgment and sentence. Failure to file the motion within these time limits constitutes a complete waiver of any right you may have to seek relief under Rule 24.035. If you file this motion, you shall include every ground known to you for vacating, setting aside, or correcting the judgment or sentence. There is no cost deposit required for you to file this motion. If you are indigent and you file your own motion, an attorney will be appointed for you. There's a few things I want to point out about what the court just read you, other than what I mentioned as I read it. In particular, the claim of ineffective assistance of counsel must be made. And then the second thing has to do with the form and how you can get it. The important thing that I want to talk about now pertains to the number of days you have to file this motion. You see two time periods. One is 180 days and the other is 90 days. What makes this a little bit confusing is you see the reference to the 90 days and an appeal. What I want you to understand is that what this document is, this Form 40, is not an appeal. It is a motion. You're asking the court to do certain things: vacate, set aside, or correct the judgment or sentence. It's called a motion. It must be filed within 180 days of you being sentenced, which is going to be the same day that the court is reading this to you. The only time it becomes 90 days is if you appeal. And again, what you're doing here is not an appeal. Mark down 180 days, and I'd file it as soon as possible. The second thing, a reference to if you are indigent, you're going to get an attorney appointed. If I am your attorney, you are indigent. So it's really important that you do not let a concern about your ability to pay for an attorney get in the way of filing this motion if you think it's justified. Even if you're uncertain, file it, and you'll get an attorney. It is important to understand that I will not be your attorney for that, and that's good. One of the claims that you could make is ineffective assistance of counsel.